Welcome to the Legal Layman Show, or welcome to it. I am Jacob Davidson from North Texas. I had made a mistake, I believe. So, I think the problem was I was on the wrong broadcast setting. I was supposed to have been streaming this 13 minutes ago. So this stream is on YouTube and on Rumble right now, but the YouTube stream was not active for the past however many minutes, so I had to basically restart. I was able to do it where I didn't have to completely restart the Rumble stream, so thank God for that. But it was a little frustrating. But I got it resolved, and that's what's important. Is my Rumble good? Alright, so I think it's good. I thought I had the show set up properly. I was gonna do it right. Damn it. I'm a little disappointed. It sucks. Gonna get the chats all set up so I can see them while I'm streaming. Alright, for the YouTube side of things, this will be a repeat for the Rumble side. I'm streaming on both YouTube and Rumble, so that will be fun. And not only that, I have something special. So the Rumble thing was part 2 of the 2 special thing that I've got going on. The second side of it is I now have a partnership or an affiliate thing going on. So the Dragon's Treasure that you can find in the description, I have partnered with them or done an affiliate link, or I got an affiliate link. And now if you go to Dragon's Treasure and use Layman or code Layman at checkout, you'll get 10% off of any purchases on tea, merchandise, teaware, anything on the storefront will be discounted. So have fun with that. Hopefully you get to use it. I need to clean this side off. Anyway, for the topics today, I will have the 5th Circuit ruling on the FDA abortifacient drug mifepristone, or mifepristone. It's probably mifepristone. So the stream started off a little late because I didn't think I was going to be able to do it anyway. But I'm going to be able to do it from 5 or 5-ish till 7 o'clock or 7:30 hopefully. And then right after that I'll have to leave to go to work. So it's a fun time. Thought I wasn't going to be able to do the stream. So let's get started with the topic at hand, and hope I don't want to kill myself this time, because I usually do whenever I do these legal things. It's mostly reading language. So here we are. The United States District Court for the Northern District of Texas Amarillo Division. Alliance for Hippocratic Medicine et al. Is the plaintiff versus U.S. Food and Drug Administration, which is the defendant. Memorandum, opinion, and order. Before the court is plaintiff's motion for preliminary injunction motion, ECF number 6, filed on November 18th, 2022. The courts grant the motion in part. So here's the background of why the judge ruled, or what the whole case is about. Over 20 years ago, the United States Food, or the FDA, I'm not going to say that, approved a chemical abortion 2000 approval. The legality of the 2000 approval is now before the courts. Why did it take 2 decades for judicial review in federal court? After all, plaintiff's petition challenged the 2000 approval date back to the year 2002, right? Simply put, FDA stonewalled judicial review until now. Before plaintiffs filed this case, FDA ignored their petition for over 16 years, even though the law requires an agency response within 180 days of receipt of the petition. 21 CFR, I need to figure out these acronyms or abbreviations. Code of Federal Regulations? Ah, there we go. Code of Federal Regulations, subsection 10.30E2. But FDA waited 4,971 days to adjudicate plaintiff's first petition and 994 days to adjudicate the second. See ESF ECF, electronic filing, okay. ECF, NOS, god damn it. 114, 121, or 128, 136, and 144. The 2002 petition, 2019 petition, respectively. Had FDA responded to plaintiff's petition within 360 days, 360 total days allotted, the case would have been in federal court decades earlier. Instead, FDA postponed and procrastinated for nearly 6,000 days. Plaintiffs are doctors and national medical associations that provide health care for pregnant and post-abortive women. Post-abortive women and girls, rather. Plaintiffs sued defendants to challenge multiple administrative actions culminating in the 2000 approval of the chemical abortion regime of mifepristone. Electronic filing number 1 at 2 mifepristone, also known as RU489 or 486 or Mifeprex, is a synthetic steroid that blocks the hormone progesterone, halts nutrition, and ultimately starves the unborn human until death. Electronic filing 7 at 781. That's a footnote. Because mifepristone alone will not always keep the abortion, FDA mandates a 2-step drug regime. Mifepristone to kill the unborn human, followed by misoprostol to induce cramping and contractions to expel the unborn human from the mother's womb, ID at 8. Or in demonstration, I'm guessing. For the footnote of the first one, 7.8, jurists often use the word fetus to inaccurately identify unborn humans in unscientific ways. The word fetus refers to a specific gestational stage of development, as opposed to the zygote, blastocyst, and embryo stages. See Robert P. George and Christopher Tolfson, Embryo 2758. Explain the stages of an unborn human because other jurists use the term unborn human or unborn child interchangeably, and because both terms are inclusive of multiple gestational stages relevant to the FDA approval. 2016 changes and 2021 changes, this court uses unborn human or unborn child terminology throughout this order as appropriate. So fetus to this judge is not an appropriate use of the term for the general categorization of the pregnancy. All right. Also, I want to step back a little bit on an opinion I stated yesterday. I voiced a very firm opinion at the judge But I made that opinion without knowing the court order or the ruling, and I was looking for this. So hopefully, with a new understanding of the totality of the judge's order, I'll have a better way to vocalize an opinion towards this judge. Though my baseline is, while I disagree with abortion, I think this pill, if effective, should be able to stand in the market because it's a one-person act to do this rather than doctors scraping out in a brutal way. In 1996, the Population Council, second footnote, Population Council was founded by John D. Rockefeller in 1952 after he convened a conference with population activists such as Planned Parenthood's director and several well-known eugenicists, Matthew Connelly, Fatal Misconception, The Struggle to Control World Population. The conference attendees discussed the problem of quality, John D. Rockefeller on the origins of the Population Council, Population and Development, Dev Rev 49, 493, 496. They concluded that modern civilization had reduced the operation of natural selection by saving more weak lives and enabling them to reproduce, thereby resulting in a downward trend in genetic quality. Oh. Eugenicists. The Population Council filed a new drug application, NDA, with FDA for mifepristone. Electronic filing numbers 1 at 35. Shortly thereafter, FDA reset the NDA from standard to priority review. ID and court term. All purposes short from citation that may be used for any cited authority except internal cross-reference. Is an all-purpose short form citation. So short citation court term. I'll probably have to figure that out later. Shortly thereafter, FDA reset to priority ID. In February 2000, FDA wrote a letter to the Population Council stating that adequate information had not been presented to demonstrate that the drug, when marketed in accordance with terms of distribution proposed, is safe and effective for use as recommended. Number 1 through 24 at 6, emphasis added. FDA also noted that the restriction on distribution will need to be amended. Mere months later, FDA approved the chemical abortion regime under Subpart H, commonly known as accelerated approval, and originally designed to expedite investigational HIV medications during the AIDS epidemic. Footnote 3. Jessica Holden, Claudia, and Shahaza Somerville. FDA's expedited review process. The need for speed. 35 applied clinical trials, 17 through 18. 2015. In 1992, in response to the push by AIDS advocates to make the investigational anti-AIDS drug azithromycin AZT accessible, the FDA enacted Subpart H, commonly referred to as accelerated approval, to give rise to the expedited review of the drugs by FDA. I guess this would also hit up the COVID stuff because they had that under accelerated. Literally named Operation Warp Speed. Where was I? Okay. Subpart H accelerates the approval of drugs that have been studied for safe and effectiveness in treating serious or life-threatening illness, and that providing meaningful therapeutic benefits to patients over existing treatments, and e.g. ability to treat patients and responsive to or intolerant of available therapy, or improves patient response over available therapy. 22 CFR, or Code Federal Regulations, subsection 314-500, FDA then imposed post-approval restrictions to assure safe use, see 21 Code Federal Regulations, subsection 314-520. These restrictions were later adopted when Subpart H was codified as Risk Evaluation and Mitigation Strategy, REMS, to ensure that the benefits of the drugs outweighed the risk. 21 United States Code, subsection 355, 1A1, 2. The drugs were limited to women and girls with unborn children aged 7 weeks gestation or younger. Electronic code filing number 7 at 9. FDA also required three in-person office visits. The first to administer mifepristone, the second to administer mifepristone, and the third to assess any complications and ensure that there were no fetal remains in the womb. Additionally, abortionists were required to be properly trained to administer the regime and to report all adverse events from the drug. Plaintiffs American Associated of Pro-Life Obstetricians and Gynecologists, or APLOG for short, and Christian Medical and Dental Association filed the 2002 petition with FDA challenging the 2000 approval ID. In 2006, the U.S. House Subcommittee on Criminal Justice, Drug Policy, and Human Resources expressed the same concerns and held a hearing to investigate FDA's handling. Alright, that's the footnote was for the need for speed. To investigate FDA's handling of mifepristone and its subsequent monitoring of the drug. Subsection or footnote 4. See FDA RU 486, lowering the standard for women's health. Hearing before the Subcommittee on Criminal Justice, Drug Policy, and Human Resource of the H Committee, Government Reform. It's a subcommittee report. Then Chairman Sauter recommended that mifepristone was associated with the death of at least 8 women and 9 life-threatening incidents, 232 hospitalizations, 116 blood transfusions, and 8 cases of infections. Oh. Well then. Sorry. Additionally, Chairman Sauter noted more than 950 adverse event cases associated with mifepristone out of only 575,000 prescriptions at most. I'm not a smart cookie. I need to figure out that calculation number. Find percentage of... Sorry, give me just a moment. I gotta... This is making my brain... So according to this calculator that I used, because I'm not very smart, 950 adverse cases out of... Hold on. $950 adverse cases out of 575,000 prescriptions at most, with subsection 6. Five infections. Transcripts is 0.0 or 0.17%. But I guess if you scale that up, that's not even a million at the time. So this was 2006 world no. United States population. Section 1. As of 2006, the Census Bureau reported the overall population had topped 300 million. 151 million women, or about 50% women. So if you multiply that by 30. No. Uh-oh. Sorry about that. Times 200. Plus 5 times 220. Getting closer. 57 times 250. 230. Times 300. Okay. $280. $270. $265. Okay. That's as close as I'm gonna get to that. So if that number, if 950 cases out of only 575,000 prescriptions, then that would make that 265 times overestimating 950 times 265. That'd be 251,750 cases of negative reactions. Sorry, I got sidetracked. This is subsection C. The subsequent staff report concluded the FDA's approval and monitoring of mifepristone was standard and necessitates the withdrawal of this dangerous and fatal product before more women suffer the known and anticipated consequences or fatalities. The report stated the universal approval demonstrated a lower standard of care for women, and mifepristone's withdrawal from the market is justified and necessary to protect the public's health. FDA rejected the 2002 petition on March 2016, nearly 14 years after it was filed. Electronic filing number 7 at 9. That same day, FDA approved several changes to the chemical abortion drug regime, including the removal of post-approval safety restrictions for pregnant women and girls, i.e., at 10, FDA increased the maximum gestational age from 7 weeks gestation to 10 weeks gestation. And FDA also, 1, changed the dosage for chemical abortion, and 2, reduced the number of required in-person office visits from 3 to 1. 3, allowed non-doctors to prescribe the administer chemical abortions, and 4, eliminated the requirement for prescribers to report non-fatal adverse events from chemical abortion. Oh. There's a whole fucking history here. So they increased the dosage, reduced the amount of in-person visits, allowed non-doctors to prescribe it, and then then took away the requirements of non-fatal adverse events to be reported. In March 2019, plaintiffs Applog and American College of Pediatricians filed the 2019 petition challenging FDA's 2016 approval of the safety restrictions ID on April 11, 2019, FDA approved GenBioPro Inc.'s abbreviated new drug ANDA for generic version of mifepristone, God damn it, without requiring or reviewing new peer review science. 2019 generic approval ID 2 years later, on April 12, 2021, FDA announced it would exercise enforcement discretion to allow dispensing of mifepristone through the mail or through a mail order pharmacy during the COVID pandemic. Notwithstanding the nearly 150-year-old Comstock Act banning the mailing of every article, instrument, substance, drug, medicine, or thing that produces abortion. Finally, on December 16, 2021, FDA denied most of plaintiffs' 2019 petitions, ID at 11. Specifically, FDA expressly rejected the 2019 petition's request to keep the in-person dispensing requirements and announced that the agency would permanently allow chemical abortion by mail. After plaintiffs filed suit, Danco Laboratories LLC, or Danco Laboratories, the holder of the NDA for mifepristone, moved to intervene as a defendant, ECF, or electronic filing number 19. On February 6, 2023, this court granted Danco's motion, electronic filing number 33. Plaintiffs now seek a preliminary injunction ordering defendants to withdraw or suspend 1. FDA's 2000 approval and 2019's approval of mifepristone tablets, 200 milligrams, thereby removing both from the list of approved drugs, FDA's 2016 changes, and 2019 generic approval, and 3. FDA's April 12, 2021 letter in December 1921 or December 16th, 2021, responding to the 2019 petition concerning the in-person dispensing requirement for mifepristone, electronic filing number 7 at 12. Additionally, plaintiffs seek to enjoin defendants from taking actions inconsistent with these orders. All right, we're getting into the actual stuff. Is my kettle still hot? There we go. Legal standard. A court may issue preliminary injunction when the movement satisfies the following 4 factors. 1. Substantial likelihood of success on the merits. 2. A substantial threat of irreparable harm if the injunction does not issue. 3. The threatened injury outweighs any harm that will result if the injunction is granted. The threatened injury outweighs any harm that will result. Yeah. The grant of an injunction is in the public interest. See Louisiana v. Becerra, 20F 4 262, or 5th Circuit 2021. The purpose of the preliminary injunction is always to prevent irreparable injury so as to preserve the court's ability to render a meaningful decision on the merits. Canal authority? Hold on. Canal Authority. Oh yeah, Canal Authority of State of Florida versus Callaway. Fifth Circuit, 1974. The same standards apply to prevent irreparable injury under the Administrative Procedure Act, APA. See USC subsection 705, Wages and White Lines, Invisible LLC versus U.S. Food Drug FDA 16 or Fifth Circuit 2021. Oh, these are all Fifth Circuit rulings. Analysis or analysis. A. Plaintiffs have standing. The judicial power of the federal courts is limited to certain cases and controversies. U.S. Constitution, Article 3, subsection 2. The case or controversy requirement requires a plaintiff to establish he has standings to sue. See Cibola Waste Incorporation versus City of San Antonio. Fifth Circuit 2013, 13. To have standing, the party invoking federal jurisdiction must show that he suffered an injury in fact that is concrete, particularized, and actual or imminent. 2. That the injury was likely caused by the defendant. And 3. The injury would likely be redressed by judicial relief. TransUnion LLC versus Ramirez, 141 in 2001. Courts should assess whether the alleged injury to the plaintiff has a close relationship to harm traditionally recognized as providing a basis for a lawsuit in American courts, ID at 2204. Standing is not dispensed in gross, rather plaintiffs must demonstrate standing for each claim that they press and for each form of relief they seek. For example, injunctive relief and damages, ID at 2208. Plaintiffs' medical associations have associational standing. An association or organization can establish an injury, in fact, through either two theories, appropriately called associational standing and organizational standing, or OCA Greater Housing or House versus Texas, Fifth Circuit 2017. Under theory of associational standing, an association has standing to bring a suit on behalf of its members when its members would otherwise have standing to sue in their own right. The interest at stake or germane to the organization's purpose, and neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit. This versus United States Consumer Production Safety Commission, probably. Texas Association of Motherfuckers versus United States. Yeah. I'm just going to assume that MFRS just stands for motherfuckers. And I'm going to assume that Texas has an association of motherfuckers. Quoting Friends of Earth Incorporation versus Laidlaw Environmental Services. Here the association's members have standing because they allege adverse events from chemical abortion drugs can overwhelm the medical system and place enormous pressure and stress on doctors during emergencies and complications. Footnote 9. James Studnicki et al. Longitudinal cohort study of emergency room utilization following mifepristone, chemical and surgical abortions. Yarvitz following mifepristone abortions grew from 3.6 of all post-abortion visits in 2002 to 33.9% of all post-abortion visits in 2015. That is a 30% growth, basically. Requires all concerns with healthcare utilization to carefully follow the ramifications of ER utilization. Where was that footnote at? Yeah. Electronic filing number 7 at 4. These emergencies consume crucial limited resources, including blood for transfusion, physician time and attention, space in hospital and medical centers, and other equipment, medicines. ECF number 1 through 5 at 9. This is especially true in maternity cases, or in maternity care deserts, geographical areas with limited physician availability. Oh, so they don't have gynecologists in those areas, or very many of them. These emergencies force doctors into situations in which they feel complicit in the elective chemical abortion by needing to remove a baby with a beating heart or pregnancy tissue as the only means to save the life of the woman or girl. ECF number 1 at 85. Members of plaintiff medical associations oppose being forced to end the life of a human being in the womb for no medical reasons, including by having to complete an incomplete elective chemical abortion. See Texas versus Becerra. Texas, August 23, 2022. Unwanted participation in elective abortions is cognizable under Article 3. Plaintiffs also argued the challenged actions prevent plaintiff doctors from practicing evidence-based medicine and have caused plaintiffs to face increased exposure to allegations of malpractice and potential liability, along with higher insurance costs. ECF number 7 at 15. The lack of information on adverse effects harms the doctor-patient relationship because women and girls are prevented from giving informed consent to providers. See also American Medical Association of Medical Ethics, Opinion 2.1.1. Informed consent is fundamental in both ethics and law. To obtain informed consent, physicians must assess the patient's ability to understand relevant medical information and present to their patient relevant information accurately and sensitively, including the burdens and risks of procedure, i.e., women also perceive the harm to the informed consent aspect of the physician-patient relationship. In one study, 14% of women and girls reported having received insufficient information about 1. Side effects, 2. Intensity of the cramping and bleeding, 3. The next steps after expelling the aborted human, and 4. Potential negative emotional reactions like fear, uncertainties, sadness, regret, and pain. See Catherine Rafferty and Tessa Longbond's #AbortionChangesYou, a case study to understand the communicative tension in women's medication abortion narratives. 36. Health Communication, 1485 through 94, 2001. Plaintiffs' physicians lack of pertinent information on chemical abortion harms their physician-patient relationship because they cannot receive informed consent from the women and girls that they treat in their clinics. Plaintiffs allege these actions have radically altered the standard of care. Electronic filing 1 through 6 at 7. Additionally, plaintiff medical associations have associational standing via their members' third-party standing to sue on behalf of their patients. See New York State Club Association Incorporation versus City of New York. This is 1988. It does not matter what specific analysis is necessary to determine that the members could bring the same suit. PA Psychiatric Association versus Green Spring Health Services. So long as the association's members have or will suffer sufficient injury to merit standing, and their members possess standing to represent the interest of third parties, then associations can advance the third-party claims of their members without... Hold on. I will not get angled. You know what I mean? Alright, sorry. Thank you. Welcome back. Back at it with the wave ends. Ugh. I got two watching, damn it. That sucks. Oh. Where the fuck was I? Standard of care changed. Additionally, plaintiff medical associations have associational standings via their members. Okay, yeah. So long as the association's member have or will have suffered sufficient injury to merit standing, and their members possess standing to represent the interest of third parties, then associations can advance the third-party claims of their members without suffering injuries themselves. Ohio Association of Independent Scholars versus Goff. Goff. Sixth Circuit, 1996. Associational standing via member schools' third-party standing to assert constitutional rights of parents to direct their children's education. 13A, Charles Allen Wright and author R. Miller, Federal Practices and Procedures. Doctors regularly achieve standing to protect the rights of their patients and their own related professional rights. The requirements for third-party standing are met here because, one, the patient have endured many intense side effects and suffered significant complications requiring medical attention and suffered stress and regret. Footnote 10, TransUnion, nor do those plaintiffs present evidence they suffered some other injuries such as emotional injury. Okay. Denny versus Deutsche Bank. The patients have a close relation to the physician members of the plaintiff members or plaintiff medical association, and 3, some hindrance exists to the patient's ability to protect their interest. See ECF number 7 at 13, Powers of Ohio. And Singleton v. Wolf, 1976. Women seeking abortions may be chilled by desire to protect the very privacy of their decision from the publicity of court suit. PA Psychiatrics 280F. A party need not face insurmountable hurdles to warrant third-party standing. The injuries suffered by patients of the Plaintiff Medical Association members are sufficient to confer associational standing. Here, the physician-patient dynamic favors third-party standing. Unlike abortionists suing on behalf of women seeking abortions, here there are no potential conflict of interest between the plaintiff physician and their patients. See June Medical Services, LLC versus Russo. Alito J. Dissenting. I thought Alito wrote the opinion. Abrogated by Dawes v. Jackson Health Organization, abortionists have a financial interest in avoiding burdensome regulations, while women seeking abortions have an interest in the preservation of regulations that protect their health. In the case where close physician-patient relationship is even stronger here than in the abortion context, see example 2168, a woman who obtains an abortion typically does not develop a close relationship with the doctor who performs the procedure. On the contrary, their relationship is generally brief and very limited. See also electronic filing number 1 through 9 at 7. In many cases, there is no doctor-patient relationship between a woman and an abortionist. So women often present to overwhelmed emergency rooms in their distress, where they are usually cared for by physicians other than the abortion prescriber. Electronic filing number 1 through 11 at 4. Because there is no follow-up additional care provided to patients by abortionists, there is no established relationship with a physician, and patients are simply left to report to the emergency room. Plaintiff's physician often spend several hours treating post-abortive women, even hospitalizing them overnight to provide treatment throughout several visits. See ECF number 1 through 8 at 5 through 6. Given the Supreme Court's jurisprudence on the close relationship between abortionists and women, the fact of this case indicate that plaintiffs' relationship with their patients are at least as close, if not closer, for the purpose of third-party standing. Finally, women who have already obtained abortions may be more hindered than women who challenge restrictions on abortions. Women who have aborted a child, especially through chemical abortion drugs that necessitate the woman seeing their aborted child once it passes, often experience shame, regret, anxiety, depression, drug abuse, and suicidal thoughts because of the abortion. See electronic filing number 96 at 25. David C. Reardon et al. Deaths associated with pregnancy outcome and record linkage study of low-income women. 95S. Scientific Medical Journal 835, I assume, 2002. Women who receive abortions have 154% higher risk of death from suicide than if they gave birth, with persistent tendencies over time across socioeconomic boundaries indicating self-destructive tendencies, depression, and other unhealthy behavior aggravated by abortion experience. Priscilla K. Coleman, Abortion and Mental Health, Quantitative Synthesis and Analysis of Research, published 1995 through 2009. British J's Psychiatry, 2011, same subsequent. Subsequently, in addition to the typical privacy concerns present in third-party standing in abortion case, adverse abortion experiences that are often deeply traumatizing pose a hindrance to a woman's ability to bring suit. In short, plaintiffs, rather than their patients, are most likely the least awkward challengers to defendants' actions. Oh, okay. All of this is basically just to say that doctors have standing to sue on behalf of their patients because the patients might be more awkward or more damaged in bringing the suit for their patients. Okay, I'm starting to see this judge's logic here now. I kind of had the presumption that this could have been incoherent, considering the background, and understandably so, the background of this judge. But everything here seems to stand firmly in some case of law somewhere. And with the overturning of Roe, this is basically how we're going to have to proceed. It'll be very interesting to see how it does proceed. I wonder about that Washington opinion. Washington Judge mifepristone ruling document. Oh. Hold up. Alright, I should have just gone to camera focus rather than be right back. So sorry about that. I should have been more thoughtful on it. So this is the 2023 FDA. Virgin Washington documentation versus Chad Texas documentation. I'll see if this is not the only version of it. Okay, so it is. Save as PDF. Denied motion. Granted motion. Alright. That'll source out my documentation. I'll probably go over this tomorrow or day after. Entirely depends on how my night's gonna go. Number 2, plaintiff medical associations have organizational standing. Organizational standing does not depend on the standing of the organization members. OCA 867 FD at whatever. The organization can establish standing in its own name if it meets the same standing test that applies to the individual. ID internal marks omitted. An organization can have standing if it is proven to a drain on its resources resulting from counteracting the effects of the defendant's action. LA Acorn Fairhouse versus LeBlanc. See also Zimmerman versus City of Austin, Texas. Fifth Circuit. Also, if I don't wrap this up before 7 o'clock, I have an opinion for Abbott later that I'll voice out very openly as a wrap up and then send everybody off. Changing one's plan or strategy in response to allegedly injurious law can itself be sufficient injury to confer standing. So you have to do something differently or plan differently. To bad law, you have standing to sue on the law. Such concrete and demonstrable injury to the organization's activity with the consequent drain on the organization resources constitutes far more than simply a setback to the organization's abstract social interest. Heaven's Reality Corp versus Coleman. One way an organization can establish standing is by identifying specific projects that it had put on hold or otherwise curtail in order to respond to the challenge action. Texas State Lulac versus Elfant. This is not a heightening of the Luan standard. Luan versus Deaths of Wildlife. Luan standard. When Congress authorized private parties to bring claims based on procedural wrongs, these plaintiffs still must show a concrete and imminent injury to establish standing. Oh, okay. So Congress got shafted here. Alright, alright. It's not a heightening of the Lujan standard, but an example of how to justify it by pointing to a non-litigation related expense. OCA, blah. Plaintiffs need to identify specific projects that they have placed on hold or otherwise curtailed. La Union del Pueblo Entero v. Abbott, number 521. At 31, Texas August, blah. Whether this is simply the most secure foundation to establish organizational standing, 13A, Charles Allen Wright, and Arthur R. Miller, Federal Practice and Procedure, subsection 33531.9.5. Furthermore, at the pleading stage, we liberally construe allegations of injury, Bazette versus United States, 714 Federal, I guess, appendix or approximation. This has to be appendix 336 and 339, 5th Circuit, 2017. Quoting Little versus KPMG LLP. Here, plaintiffs' medical associations have standing via diversionary injury because the FDA's failure to require reporting of all adverse events. Plaintiffs allege FDA's actions have frustrated their ability to educate and inform their member physicians through their member physicians, their patients, and the public on the dangers of chemical abortion drugs. Electronic filing number 7 at 12, as a result of plaintiffs attest that they have fuck. My bad. I forgot to say this one. So need to not specify projects that they have placed on hold or otherwise curtailed. That goes to, at hearing of Donko argued, Alfant held there was no standing where organizations failed to identify specific projects put on hold. Electronic filing numbers 136 at 125. This is incorrect. The Fifth Circuit and Alfant assumed without deciding the plaintiffs pled an injury in fact, but held they did not have standing because the causation and redressability elements were not met. Oh. So Donko argued Alfant. The court said that was not the reason, but rather the causation and redressability elements were not met. To lawyers out there, try not to bullshit your arguings and hearings or pleadings. You might get called out on it in a footnote. You got to be on point with your law. So plaintiffs allege FDA's actions have frustrated their ability to educate their member physicians, their patients, and the public of the dangers of the abortion drugs. As a result, plaintiffs attest that they have diverted valuable resources away from advocacy and educational efforts to compensate for the lack of information. Electronic filing number 1 at 91. Such diversions expend considerable time, energy, and resources to the detriment of the other priorities and functions and impair plaintiffs' ability to carry out their educational purposes. An example, NAACP versus City of Coll, Texas. Similarly, plaintiffs allege their efforts to respond to FDA's actions have taken them away from their priorities such as fundraising and membership recruitment and retention. Electronic filing numbers 1 through 4 at 6 and 1 through 5 at 11. Consequently, plaintiffs have recalibrated their outreach efforts to spend extra time and money educating their members about the dangers of chemical abortion drugs. Combining these facts are sufficient to confer organizational standing. COCA, finding organizational standings even where the injury was not large. Injuries, in fact, need not measure more than an identifiable trifle, internal admitted. I just want to take this moment to remind everybody, since we're at a breaking point, in page 13, plaintiff's alleged injury, that if you're watching this right now and you want some tea, some really good tea, you can hear the kettle going off. If you shop at the Dragon's Treasure and use code LAYMAN, you can get 10% off your purchase. It's great. And I totally do not have a financial interest in this, for I'm not getting 5% back. I am. I do have a financial interest. That's why I did it. And hopefully anybody who's interested in some tea will have an appreciation for the anime-centric theming of the tea's names, and will be able to appreciate the flavors, because the problem is they're pretty good. And I've drank about 6 different teas. I have had the Iroh's Legacy, Magic Girl Venus, which is this one, I have matcha tea. That's, I think, ceremonial, or the traditional green tea from Japanese, or that the Japanese people typically serve. I have drank Strawberry White. I think I drank this yesterday. It was very good. Magic Girl Venus tastes like oranges. And a note from the tea man, or the one guy who runs Dragon Treasure. There's going to be a change to Magic Girl Venus to make it more orangey. It's going to add more orange peels and orange flavoring to it. And I think tomorrow or the day after, I'll do the Princess Peach Oolong tea. The fascinating things about these is that they have the instructions of what temperature, depending on the kettle you have. If you have a kettle like this, it comes with a heating element base. And it has, different temperature options that you can select. And if anybody's confused, 212 is boiling temperature. Side note, if you have noodles and you don't want to boil water in a kettle or microwave it, 212 in that, pour it in your noodles, and it'll get it right. I love it. I always wanted to shill something, so this is probably my first and most exciting one. Back to the topic. Also, this thing is from T-Man as well. He makes it easy to get your tea. Prepare it and drink it. Plaintiffs' alleged injuries are concrete and redressable. Defendants contend that plaintiff's theory of standing depending upon layer after layer of speculation, ECF number 28 at 20, but plaintiffs allege FDA's chemical abortion regime caused intense side effects and significant complications for their patients requiring medical intervention and attention. ECF number 7 at 13. See an example or in demonstration. Fuck. Similar. So earlier at the whole plaintiffs allege their efforts to respond to FDA's have taken away resources from recruitment. It is true that plaintiffs must allege their activities in response to the challenge actions differ from their routine activities. Or see that case, but plaintiffs have done so. For example, plaintiffs argue they have conducted independent studies and analysis of available data to determine to the detriment of their advocacy, educational, and recruitment efforts. The Fifth Circuit found diversionary injuries to constitute injuries. In fact, even where it was less clear, the plaintiffs diverted from routine activities. Now, injuries, in fact, where organizations regularly conducted voter registration drives and expended resources registering voters in low registration areas who would have already been registered if not for the challenged actions. All right, so there's that footnote. The harms that the FDA have... Alright, I just picked a point and went. Layer after layer, speculation, plaintiff's chemical regime cause intense side effects, and significant complications for their patients requiring medical intervention and attention. The harms that the FDA have wreaked on women and girls have also injured and will continue to injure plaintiff doctors and their medical practices. I mean, I kind of don't care so much for the doctors and their medical practices, but I do care about the ladies. The FDA's actions have placed enormous pressure and stress on the plaintiff's doctors during these emergency situations. ID at 15. The FDA has caused plaintiff's doctors to face increased exposure to allegations of malpractice and potential liability, along with higher insurance costs. That was from earlier. In fact, plaintiff's declarations list specific events where plaintiff's physicians provided emergency care to women suffering from chemical abortions. Electronic filing numbers 1 through 8 at 5 through 6, 1 through 9 at 4 through 9, 1 through 10 at 6 through 7, 1 through 11 at 5 through 6. And defendants even concede the existence of adverse... The defendants even concede the existence of adverse events related to the chemical abortion drugs. See electronic filing numbers 28 at 21. Consequently, defendants misconstrue plaintiff's pleading and mischaracterize plaintiff's evidence as speculative. It is not. Past injuries thus distinguish this case from Clapper v. Amnesty and Intel, or USA, where the Supreme Court held threatened injury must be certainly impeding to constitute injury in fact. Threatened injury must be certainly impeding to constitute injury in fact. Okay, I see. Quoting Whitmore versus Arkansas 495 USA, where there are no past injuries in this case, the alleged future harms are still less attenuated than those in Clapper. Finding highly attenuated chain of 5 separate possibilities needing to align for the alleged harm to occur. Were there no past injuries in this case, the alleged future harms are still less attenuated. Okay. Unlike in Clapper, where the alleged injury depended on a long and tenuous chain of contingent events, the chain of events framework in this case involves fewer steps and no unfounded assumptions. See also ECF numbers 1 through 31 at 10. Roughly 8% of women who use abortion pills will require surgical abortions. That is unfortunate. Discussing a study in which 18.3% of women require surgical intervention after chemical abortions, and as post-Whitmore cases have demonstrated, the certainly impending standard for an imminent injury is not as demanding as it sounds. See TransUnion 141, South Circuit probably. A material risk of future harm can suffice so long as the risk of harm is sufficiently imminent and substantial. Susan B. Anthony List versus Dryhouse. An allegation of future injury may suffice if the injury or the threatened injury is certainly impeding or there is a substantial risk the harm will occur. Emphasis added Clapper, Massachusetts versus EPA. Even a small probability of an injury is sufficient, provided, of course, that the relief sought would, if granted, reduce the probability. For similar reasons, defendants' reliance on the City of Los Angeles versus Lyons also fails. 461 U.S. 95, 1983. There, the Supreme Court held Lyons did not have standing to seek injunctive relief because There was no fighting that lions faced the real and immediate threat of again being illegally choked. By Los Angeles police at 1:10. The lion's holding is based on the obvious proposition that a prospective remedy will provide no relief for an injury that is and likely will remain entirely in the past. I am curious about this one. Los Angeles versus Lions. I guess 95 was the year? The police officer of City Los Angeles stopped Adolph Lyons for a traffic code violation. Lyons offered no resistance. The officer, without provocation, seized Lyons and applied a chokehold, rendered Lyons unconscious and damaged his larynx, along with damages against the officers. Lyons sought an injunctive, barring that they use chokeholds. Four to five to four decision court held that the courts were without jurisdiction to entertain Lyons' claim for injunctive relief. Oh, they didn't even hear that case. They denied it. Courts can kind of fuck themselves. They're not in my good graces sometimes. For similar reasons, defendants, they relied Lyons' space remain in the past. Post Workers Union versus Frank, 1990. No such reluctance, however, is warranted here. Considering FDA, where's earlier grant even of small ability to injunctive relief to prevent injury if that reduces the possibility. Defendants' reliance on Spokio Inc. versus Robbins is also unavailing. 57 U.S. 33 330 2016. Court should indeed assess whether the alleged injury to the plaintiffs has a close relationship to harm traditionally recognized as the basis for a lawsuit in American courts. But a plaintiff does not need to demonstrate the level of harm he has suffered. It would be actionable under similar common law causes of action. Perez versus McCreary, Bragg and Allen. Rather, plaintiffs only need to show the type of harm alleged suffered is similar in kind to the type of harm that the common law has recognized as actionable. Evidence of injury required by TransUnion is not burdensome. Harm resulting from unsafe drug is similar to harm actionable under the common law. Okay. Back to where I was here. No such reluctance. Considering FDA's 2021 decision to promote mail-in chemical abortion, many women and girls will consume mifepristone without physician supervision, and in maternity care deserts, women may not have ready access to emergency care. In some, there are fewer safety restrictions for women and girls today than ever before. Plaintiffs have good reasons to believe their alleged injuries will continue in the future and possibly with greater frequency than in the past. Defendants next argue plaintiff's theory depend on unfettered choices made by independent actors not before the courts and whose exercise of broad and legitimate discretion the courts cannot presume either to control or predict. Quoting Lujan, a plaintiff must allege personal injury fairly traceable to the defendant's allegedly unlawful conduct and likely to be redressed by requested relief. Versus Wright, 468, 1984, abrogated on other grounds by Lexmark, Intel Incorporation, or whatever. Static Control Components Incorporation, 2014. See also Simon v. This Group Organization, 1976. In other words, the case for controversy limitation of Article 3 still requires that a federal court act only to redress injury that fairly can be traced to the challenged action of a defendant and not injury that results from the independent actions of some third party not for the court. In this case, a favorable decision would likely relieve plaintiffs of at least some of the injuries alleged caused by the FDA. See Larson v. Valentine, 456, U.S. It's in 1982. Plaintiffs need not show that a favorable decision will relieve their every injury. Duke Power Company versus Carolina, holy God. Carolina Environmental Study Group in 1978. A substantial likelihood the requested relief of redressing the alleged injury is enough. A plaintiff need only show that a favorable ruling could potentially lessen its injury. Texas versus Becerra, 2021. That the plaintiffs have brought forth specific evidence and examples of how they will be harmed. Distinguishes this case from others where a third party's action might have hurt the plaintiff. And redressability is satisfied even if relief must filter downstream through third parties uncertain to comply with the results, provided the relief would either 1. Remove an obstacle for a non-party to act in a way favorable to the plaintiff, or 2. Influence a non-party to act in such a way. See example Department of Communications versus New York. Third parties will likely react in predictable ways. Bennett versus Spear, 1997. Defendant actions need not be the very last step in the chain of causation. Therefore, plaintiffs' alleged injuries are fairly traceable to defendants and redressability by a favorable decision. I'm going to take a look ahead to everything else. This might have to wrap up pretty soon. I am a little proud of how far I've gotten through this case, though. Or the ruling, rather. Number 4, plaintiffs are within their zone of interest. Plaintiffs are also within the zone of interest of the Federal Food, Drug and Cosmetic Act, FFDDC. FDA is now FFDD or FFDCA. In the Comstock Act, plaintiffs suing under the APA must assert an interest that is arguably within the zone of interest to be protected or regulated by the statute that they say was violated. Texas v. United States, 5th Circuit, 2015. Internal marks omitted. The zone of interest test is not meant to be especially demanding and is applied in keeping with Congress's evident intent when enacting the APA to make agency action presumptively reviewable. The zone of interest test looks at the law's substantive provisions to determine what interest and hence which plaintiffs are protected. Simmons versus UBS Financial Services, 2020. That interest at times may reflect aesthetic, conversational, and recreational as well as economic values. Association of Data Processing Service Organization Incorporation versus Camp. A federal court's obligation to hear and decide cases within its jurisdiction is virtually unflagging. Lexmark 572. And the trend is towards enlargement of the class of people who may protest administrative actions. Camp 397. No explicit statutory provision is necessary to confer standing. The test forecloses suit only when plaintiff's interests are so marginally related or inconsistent with the purposes implicit in the statute that it cannot possibly be assumed that Congress intended to permit the lawsuit. Texas versus United States. In other words, there is no presumption against judicial review and in favor of administrative absolutism unless the purpose is fairly discernible in the statutory scheme. Courts must decide if Congress has in express or implied terms precluded judicial review or committed the challenged action entirely to administrative discretion. Defendants argue that plaintiffs identify no particular provision of the FFDCA protecting their interest, electronic filing number 28 at 26, but plaintiffs' interests are not marginally related to the purposes implicit in the FFDCA. The statute's substantive provisions protect the safety of physicians' patients and the integrity of the physicians-patient relationship. See generally 21 U.S.C. subsection 355. Furthermore, this court finds the plaintiffs have third-party standings on behalf of their patients. Plaintiffs' patients are within zone of interest of the FFDCA because patients seek safe and effective medical procedures. Likewise, plaintiffs are within the zone of interest of the Comstock Act. The statute indicates a national policy of discontinuance abortions is inimical to the national life. I'm going to show my illiteracy. Inimical. Inimical. Tending to obstruct or harmful, injurious, detrimental, unfriendly, hostile. Okay. Alright, there we go. I learned a new fucking word today. Indicates a national policy of discountenancing abortion is inimical to national life. Boers v. United States. See also Bulger versus v. Young's Drugs Production Corp. The thrust of the Comstock Act was to prevent males from being used to corrupt public morals. There is no evidence that Congress sought to preclude judicial review of administrative drug rulings or administrative rulings by FDA as to the legitimate scope of activities available concerning chemical abortion drugs under these statutes. For all the aforementioned reasons, plaintiffs have standing. The short little section. B. Plaintiffs' claims are reviewable. Defendants averse that all plaintiffs' claims are untimely or unexhausted except their challenges FDA December 16, 2021 response to 2019 citizen petition ECF number 28 at 26. This includes plaintiffs' challenge to 1. the 2001 approval of and FDA's 2016 response to the 2002 petition challenging that approval, 2019 generic approval, and 3. April 2021 letter as As for FDA's December 2021 response to 2019 petition, defendants maintain review is limited to narrow issues presented in the 2019 petition, which did not include arguments concerning the Comstock Act, ID 27 through 28, footnote 15. The court disagrees with each of these arguments. The court refers to the 2000 approval and the 2016 challenges and denial of the 2002 petition and 2019 generic approval collectively as FDA's pre-2021 actions. Similarly, the courts refer to FDA's April 2021 letter and December 2020 response as FDA's 2021 actions. So we have new language for old terms. Just a moment. Number 1, FDA reopened its decision in 2016 and 2021. FDA's final decision on a citizen's petition constitutes a final agency action under the APA, 21 Code of Federal Regulations, and 10.45C. Challenges to agency actions have a 6-year statute of limitation period. See 21 or 28 USC subsection 2401A. Therefore, the statute of limitations for the challenging of the 2000 approval began running on March 2016, the date of FDA's denial of the 2000 petition, because the 2016 denial of the 2002 petition occurred more than 6 years before the plaintiffs filed the suit. Defendants argued the challenge is untimely, electronic filing number 28 at 26. But if the agency opened the issue up anew and then re-examined and reaffirmed its prior decision, the agency's second action, rather than the original decision, starts the limitations period. See Texas versus Biden, 2021. Revved in part and other grounds. The reopening doctrine arises where an agency conducts a ruling or adopts a policy of an issue at one time and then in a later rulemaking restates the policy or otherwise addresses the issue again without altering the original decision. Wash all of tech workers versus U.S. Department of Homeland Security. The reopener doctrine allows an otherwise untimely challenge. Just a moment. Now, if only I could consolidate my Rumble views and my YouTube views into the 1.5 group, 5 views. Okay, I'm back. The reopening doctrine arises when the agency conducts rulemaking without or changing the results. Okay, yeah, this is pretty close to where I landed on. Courts have even applied the doctrine where agencies decided to not engage in rulemaking and then revisit the reaffirming decision. And Public Citizen versus Nuclear Regulation Commission. The reopening doctrine allows an otherwise untimely challenge to proceed where an agency has either explicitly or implicitly undertaken to re-examine its former choices. CTIA Wireless Association, blah blah, DC. Agency reconsidered policy by reaffirming policy and offering 2 new jurisdictions not found in prior orders. In the rulemaking context, the courts have identified 4 non-exhaustive factors to apply the doctrine where the agency 1. Proposed to make some change in the rules or policies, and 2. Called for comment on new or changed provisions, but at the same time, 3. Explained the unchanged republished portions, and 4. Responded to at least one comment aimed at the previously decided issue. Tripoli Rocketry Association Incorporation versus U.S. Bureau of Alcohol, Tobacco, and Firearms. The ATF in an abortion document. Fuck. But a court cannot stop there. It must look to the entire context of the rulemaking, including all relevant proposals and reactions of the agency, to determine whether an issue was in fact reopened. Citizens, I don't know what this word is. It's either public or publicized or publication or whatever. For example, an agency can reopen a prior action if it removes restrictions or safeguards released or related to the first action or affects a sea change in the regulatory scheme. See Sierra Club versus EPA, National Biodiesel law. Declining to apply doctrine when the basic regulatory scheme remained unchanged. Hold on. What is happening in that chat? Well then. Where was I? I got distracted. Sea change, subject to renewal. Declining to apply doctrine when the basic regulatory scheme remained unchanged. Citizen blah. Agency reopens decisions when it reiterates a policy in such a way as to render the policy subject to renewed challenge on any substantive grounds. In adjudication context, an agency need not solicit or respond to comments to reopen a decision because adjudication does not require notice and comment procedure. See 5 U.S.C. subsection. Alright. So this is subsection, I think. Subsection symbol. Section symbol. Okay. See USC subsection 553C and 554 subsection. The reopening doctrine has been applied in adjudication contexts where an agency undertakes a serious substantive reconsideration of a prior administrative decision. A petition for reconsideration can restart section 2401A, a limitation period, if the agency reopens the action based on finding of new evidence or that the petition reflects some changed circumstance. PVV United States 128 DDC 2015. Reopening in 2011 occurred where agency elected to conduct a substantive review of service members' 1968 application to correct military records. For formal agency adjudication, even in order stating only that it is denying reconsideration, is not conclusive if the agency has altered its original decision. Cinder Court versus Magaw, not to be confused from MAGA. The standard for reopening is satisfied here. FDA's requirements for distribution in its 2000 approval originally included in-person dispensing from doctors to patients, secure shipping procedures, tracking system ability, use of authorized distributors and agents, and provisions of the drug through direct confidential physician direct distribution systems that ensures only qualified physicians will receive the drug for patient dispensing. C. Electronic filing number 1 at 40. FDA's 2016 changes to regulatory scheme included the following: extending the maximum gestational age at which woman or girl can abort her unborn child from 49 days to 70 days, altering mifepristone dosage from 600 milligrams to 200 milligrams, and the misoprostol dosage from 400 to 800, and misoprostol administration from oral to buccal. Yeah, eliminating the requirement that administrations of misoprostol occur in clinic, broadening the window for misoprostol administration to include a range of 24 to 48 hours after taking mifepristone instead of 48 hours afterwards, adding a repeat 800 microgram buccal dose of misoprostol in the event of an incomplete chemical abortion, removing requirements for in-person follow-up exam after an abortion, allowing health providers other than physicians to dispense and administer the chemical abortion drugs, and eliminating the requirement for prescribers to report all non-fatal serious adverse events from chemical abortion drugs. So 1, 2, 3, 4. 4 pages. After the 4th page, when I get to this section, or when I get to the April 2021 decision, I'm going to probably wrap up so I can wind down a little bit before I have to go to work. At 54, and in 2021, FDA removed in-person dispensing requirements, a signal that it will soon allow pharmacies to dispense chemical abortion drugs. ID at 68. Plaintiffs warn that without this requirement, there is a dramatically reduced chance that the prescribers can confirm pregnancy and gestational age, discover ectopic pregnancies, and identify a victim of abuse or human trafficking being coerced into having chemical abortions. This is an interesting argument. FDA's 2016-2021 change thus significantly departed from the agency's original approval of the abortion regimen. FDA repeatedly altered its original decision by removing safeguards and changing regulatory schemes for chemical abortions. Sierra Club these rulings. Additionally, FDA's response to the 2019 petition explicitly states FDA undertook a full review of mifepristone's REMS programs. REMS. Risk Evaluation and Mitigation Program. Undertook a full review of the mifepristone Risk Evaluation Mitigation Strategy Program in 2021. ECF number 1 through 4 at 7. Footnote 17. See also questions and answers on mifepristone's medical termination of pregnancy through 10 weeks gestation. And here has the text. FDA review. Agency reopened decision by conducting thorough review of the merits even where the order did not state it was a reconsideration and did not reference prior decision. The FDA even granted the 2019 petition in part, ECF number 1 through 44 at 3A, or 3, a full review of REMS for a drug with known serious side effect or serious risks necessarily considers the possibility that the drug is too dangerous to be on the market. Any mitigation strategies notwithstanding, FDA has the authority to withdraw an approved drug application on this basis. See 21 U.S.C. subsection 355E. Because the agency reaffirmed its prior actions after undertaking a substantive reconsideration of those actions, the limitations period for those actions starts at 2021. See Pulp Citizen 901. An agency reconsiders and reaffirms original policy necessarily raises the lawfulness of the original policy for agencies have ever-present duty to ensure that the actions are lawful. Subsection A. To date, it's unclear whether the reopening doctrine has been applied in the precise context of the FDA's approval of an NDA. However, much of the rationale courts have applied in both the rulemaking and adjudication context applies here, and the court is unaware of any legal principle that would preclude the doctrine from being applied to these facts. Assuming arguendo, plaintiff's allegations are true, a contrary holding would mean that there is no judicial remedy to FDA's insistence on keeping the allegations are true. Contrary holding would mean that there is no judicial remedy to FDA's insistence on keeping an unsafe drug on the market so long as enough time has passed. Oh, okay. So assuming that the argument was correct, that would mean that there is no judicial, there's no power of the court to stop a harmful drug if you just wait long enough. It's like, I guess it needs a statute of limitations. What's it? It's like a stare decisis argument. Stare decisis. Yeah. It's like arguing stare decisis, I think. Alternatively, the court finds plaintiffs' claims are not time barred under the equitable tolling doctrine. Equitable tolling doctrine. Equitable tolling doctrine. For shorthand, equitable tolling is a court's discretionary extension of deadline provided when a litigant was prevented from complying with deadline despite legitimate efforts to do so. The concept of equitable tolling is based on notions of fairness and equity. Courts must be cautious not to apply the statute of limitations too harshly. That is coward talk. A rebuttable presumption of equitable tolling applies to lawsuits governed by the 6-year limitation period of Section 2401. Bornhold v. Brady, 1989. The existence of subsection 2401 as a catch-all provision does not necessarily mean that Congress intended the 6-year period to be applied whenever a substantive statute does not specify a limitations period. A litigant is entitled to equitable tolling of statute limitations only if the litigant establishes 2 elements: that he has been pursuing his right diligently, and 2, that some extraordinary circumstance in his way and prevented timely filing menomine Indian tribe. Menominee? However say that. Indian tribe of Wisconsin versus United States, 2016. See also Holland versus Florida, 2010. The flexibility inherent in equitable procedure enables courts to meet new situations that demand equitable intervention and to accord all relief necessary to correct particular injustices. Cleaned up. Equitable tolling is appropriate here in large part because FDA's unreasonable delay in responding to plaintiffs' 2002 and 2019 petitions, see Wild Earth Guardians versus Department of Justice. It is grossly inappropriate to apply a statute of limitations where the agency unreasonably delayed a claim because the agency could immunize its alleged unreasonable delay from judicial review simply by extending that delay for 6 years. Internal mark omitted. It took FDA 13 years, 7 months, and 9 days to respond to the 2002 petition. FDA then moved the goalposts by substantially changing the regulatory scheme on the same day it issued its response. And it took FDA 2 years, 8 months, and 17 days to respond to the 2019 petition, which challenged those decisions. Thus, in the 20 years between 2002 petition and the filing of this suit, plaintiffs were waiting on FDA for over 16 of those years. See Hill Dermaceuticals Incorporation versus U.S. Food FDA, 2007. Once citizens' petitions are submitted, the FDA commissioner is required to respond in one of 3 manners within 180 days of receipt of the petition. Quoting 21 Code of Federal Regulations, subsection 1030E2. Additionally, statutes of limitations are primarily designed to assure fairness to defendants. To assure fairness to defendants and to promote justice by preventing surprises through revival of claims that have not been allowed to slumber until evidence is lost, memories have faded, and witnesses have disappeared. Claymore versus United States. As corrected on Reg. But it has not been argued and cannot seriously be argued that the government was unfairly surprised when plaintiffs filed this suit. ID plaintiffs have been Incidentally, the FDA response is extreme, but not unprecedented. See Bayer Healthcare LLC versus FDA. FDA had not responded to 2016 petition when it approved a related ANDA in 2013. Oh, fuck. It's right there. Oh, I love this argument. I love it a lot. But it has not been argued and cannot seriously be argued that the government was unfairly surprised when plaintiffs have been reasonably diligent in pursuing their claims. See EACF number 1 through 4 at 6. After years of waiting for FDA to respond to the petition, plaintiffs called upon FDA to issue a response in 2005 and again in 2015. And the public interest in the case militates towards resolving plaintiffs' claims on merits. Accordingly, plaintiffs' challenges to FDA's pre-2021 actions concerning chemical abortion drugs are not time barred. I will certainly do a part 2 tomorrow. If not for the 3 hours I want to do them, then for the 1 hour that I can do it whenever I wake up at a better time than when I woke up today. I did not expect to do this stream today. I'm so glad I did get to do this stream today. Yeah, forehead. I will have some way of pinning this so that way I don't lose it. Probably through a screenshot of the page, which I'm doing right now, literally. So, Zeno X, if you're watching this, and sorry to the other guy who was talking to me earlier this morning, I forgot your name. I'll be better about it later, but unfortunately not today. I will probably do more of these streams whenever I can, regardless. I was very timid about doing it whenever I have someone in the room that I'm probably making wait. Or have deal with heat. But it's whatever. We're both in Texas and it's whatever. Yeah, that's fine. It's great. I'm currently saving that document, whatever, so that way I can have it pinpointed where I want it to go. Export. What the shit? Shit's going crazy. Alright, so I saved my point. I would like to remind everybody who is still watching, who will come watch on the replay, I do have a partnership. I do have something to shill. At Dragon's Treasure, if you want to have some tea, anime-based themed tea, you can in fact get some tea from the Dragon's Treasure, and code LAYMAN will get you 10% off of your purchase. I got Iroh's Legacy tea, obviously Avatar-based. When Iroh passed on to the spirit world, he left behind something for everyone to remember him. Green tea with flavor of jasmine. Simple. And I got ceremonial green tea, I believe. Or it's ceremonial Japanese. Got ceremonial grade matcha. Which has a special way of making it. I haven't made it yet. I'll try it later, well, not when I'm on stream. Everything that you see me use during the stream to make a new cup, the kettle is sold there. This dispensing thing. All you do is you fill it up with water, basically up to here, It's almost the size of the volume of this, except for like the last 2 inches of the top, or last inch of the top, is enough to fill up an entire cup about this size. And you put it on like that, and it fills in. It's got a stand for it, so you can set it down where it won't like accidentally tap something while it waits. Still alive? Alright. And that is the Dragon's Treasure. That is what the T-Man has to offer. Remember, Dragon's Treasure on checkout, code LAYMAN. I made it easy. I was wanting to be clever with it, but I decided against that. I think in the next stream, or the next 2 streams, I will be doing the Princess Peach Oolong tea. I think I have one more sample tea that I haven't tried out yet. And if you don't want to spend too much on one tea and you don't like it, just get a sample order. You'll just get 5 random teas. They include the members only tea, so you can try out if you want to get a membership. But yeah, with all that said, didn't I have a rant for... I had something to say earlier about someone for something. I think I wanted to say something against the Volusia County Sheriff's Office again, just to kind of hammer down that I hate them. Free the 4chan guy, the first one. I don't know about the second one. I think he actually made an actionable threat. I need to look into those cases. But anyone who's basically saying that this is evil, wrong, and whatnot, they're stupid. You gotta look into it first. All the news articles is basically just like, anti-abortion judge makes an anti-abortion ruling because he's anti-abortion. Something like that, to that effect. It doesn't make any comments with respect to the ruling itself. Doesn't claim any of the arguments that I've been seeing. Something to the effect of like, because like everything that I've seen so far has something to do with the fact that the FDA ruling was continued or delayed significantly, which makes a huge impact on an ability to respond to it. And the statistics relating to injuries to women were not stated in the articles relating to it. You would initially think that the ruling was completely unfounded, and the language used by unborn human is interesting, and I have never even thought about it. That unborn human is a more accurate term because a fetus is dedicated to a very particular stage of the development. So I'm learning new things just by reading this, and hopefully I'm reading it competently enough that it's not just incoherent and stupid on my part. I'm hopefully getting a better understanding. The games that the FDA has played in this is prevalent and apparent if you look at it. The 2020 ruling, or 2020 approval, the 2016 response, the changings of the rules without any kind of... They want to basically have their cake and eat it from the way it reads. They changed the rules without approval, and they're basically saying that the 2002 petition was, or the lawsuit now is untimely because the 2002 petition... But the 2002 petition had the first rule set, and 2016 petition had the new rule set that was changed out of nowhere, and then they delayed the response to that for since like then 2001. So the ruling seems to have some grounds. It'll be interesting to see this develop. I will continue this document hopefully tomorrow, like I said, or the day after. After I do that, I'm going to go into the Washington decision and try not to bash my head against the wall. So let's go back to it real quick. This is 67 pages. The Washington decision is 31 pages. I guess it takes a lot less to deny and for something to be denied. So I've got 42 pages left and then 31 pages. Hopefully that won't be too long for tomorrow. It took me 2 hours to get through 25 pages. And that was including doing some stupid amount of math later on, or earlier on in the reading of this, plus chasing down statutes. Inimical. I learned that word. I learned about a tribe. I'll try to nail down how to read this document. But as I said before, with the Dragon's Treasure code layman at checkout, I'm so happy to be doing that. I did the math on that, and I need at least 585 sales in a year on the minimum priced tea, which is a loose leaf 20 grams of the $7.99 priced tea to make even. Hopefully I'll be breaking that easily. And if you liked what you saw, if you liked what you heard, if you liked my voice, if you liked my presentation of it, please feel free to subscribe to the YouTube. Check me out on Rumble. I think I'll be able to be monetized there before I'll be monetized on YouTube. Check out my locals. It's like a Patreon, but better because they don't care about what you say. As long as you don't make a live or an actionable threat to somebody, I think they're chill with you. Other than that, I might have a few interviews on the horizon. I'm going to be asking people if I can talk to them on stream. Unfortunately, I won't be able to use the OBS layout. It'll be through StreamYard. But I'll be happy to be able to talk to them. I'm trying to get Ricada on. I want to talk religion with him. He seems like the guy that I could talk religion with. Got another individual that I'm hoping to get on, if at all, if it's possible. The man seems to be very busy with his content. On civil law, hopefully I can get some of the LawTube people on. I'm wanting to talk to Robert Gouveia right now the most, because he's covering these topics. He's covering the stuff that I'm interested in. Of course, he's watching the Watchers. If anybody can help me get in touch with them, I'd be greatly appreciative of that. Hopefully we can set up some kind of time for it. If not, thank you very much. Thank you for checking out the content. Hopefully I'll see you on Rumble, Locals. Hopefully some of you guys will purchase from my code. And with that said, that is the stream. That is all I have to say. I'll cover the rest tomorrow. Thank you for coming to the stream. Hang loose.